Washington. Of course, a city in a country so tragically affected by this crisis, we send to its people our condolences, encouragement and best wishes. David is an attorney specialising in international tax matters. He is a member of law firm Caplin Drysdale and is visiting professor of taxation and director of the International Tax Program at New York University School of Law. A frequent speaker and author on tax, he has taught international taxation at Stanford, Columbia, Harvard, Pennsylvania and New York universities and at educational institutions around the world. He's also served as a tax policy advisor for the United States Treasury, the OECD, AID and the World Bank in Eastern Europe, the former Soviet Union, Senegal, Malawi and South Africa. Whew, I have to come up for air on that one. Our local interlocutor this morning, live from Sydney, is Burnett. Chloe is a member of the New South Wales Bar, specialising in tax law. She's an active member of IFA, is a deputy president of the Australian branch, and currently chairs the recent developments panel at the International IFA Congresses. Chloe, David, good morning. Let's have a conversation.
Thanks, Paul. Morning, everyone, and good evening in the US. So the title of this webinar uses the term post-pandemic, and that's something we're cautiously talking about in Australia right now, but many other countries are right in the thick of this crisis, and the US is one of them. So the immediate focus is dealing with the crisis, and our fiscal systems are directed at that as well right now. But we're also thinking about how the world will change and adapt over the next few years. This includes our tax systems, domestic and international. So the crystal ball is looking rather cloudy right now, but we're going to give it a go. And who better to gaze into it than David Rosenbloom? Paul, in his introduction, mentioned that David lectures all around the world, and he's still doing that from his base in DC. David will be teaching US International Tax at Melbourne University in July in an online format. And if you're particularly interested, you can look to enroll for one unit or to audit the course. Now, David, can we start with you giving the audience a picture of what's happening tax-wise in the US right now?
Sure. There's always a lot going on in the US, even now. First of all, thank you. Great to see you, Chloe. It's been a couple of years, and I want to welcome everybody, all the alums from the NYU International Tax Program who are on this webinar. The U.S., I would say there are at least three major developments post-pandemic or now going on in the U.S. in the tax area. First of all, the IRS has put out a series of rulings and notices and answers to questions which basically relieve people's minds about individuals who are stuck in place. I mean, can't travel back to their homeland, can't travel back to the place where they were spending time abroad. And those, I regard those as pretty sensible, pretty commonsensible, so I don't get terribly excited about them. The US is, only tax lawyers would worry that if you're stuck because of an epidemic that there would be a tax problem. The more interesting thing, I think, Chloe, is the CARES Act. We passed a mammoth statute, and it did a lot of things, including sending out checks for $1,200 to adults and $500 to children, most people in the United States. And those are ostensibly prepayments or refunds of 2020 taxes. That's formally what they are. The people who receive them don't care. But there are two provisions of there's nothing specifically international in the CARES Act, but there are two provisions that impact international, and they interrelate, and they're very interesting. And I've been writing about them, and I've got an article in the works about them. One of them does this. It extends our net operating loss rules to carry back for 5 years, and that applies to losses incurred in 2008. Let's just stick with calendar year taxpayers to keep it simple. 2018, 2019, 2020. And so taxpayers can carry those back 5 years. Now, the Tax Cuts and Jobs Act, which we passed in December of 2017, had all sorts of international provisions. I assume that most people on this are aware, at least that occurred. And the intersection between that loss carryback and the TCJA provisions is really interesting. The TCJA, first of all, had a repatriation, a transition rule whereby all earnings going back to 1987 had to be picked up in the year 2017 under our Subpart F rules. That was a one-time event. It was all earnings for many, many years, 87 through 2017, 30 years. And that happened in 2017, which would be one of the years impacted by the carryback. And Congress, in passing the carryback rule, took note of this and figured people would not want to apply losses against that income because that income is preferentially taxed. And so they allowed people to do one of two things. They could skip a year in which there was an inclusion of the repatriation amount, or if the year was covered, they could not apply the losses against that income. And as far as that went, it was fine. The problem is that there's a lot of other preferential income that gets hit in the 5-year carryback. The GILTI effective rate of tax on global intangible low-taxed income is 10.5%. The effective rate of tax on foreign-derived intangible income, that's export income, is 13.125%. So taxpayers are going to have a terrible time figuring out what to do. It's really tricky. You can forego the 5-year carryback, but your choice is either to take it or not take it. And once you start the period of application of losses, they roll forward year after year. The other thing that's in this mix is that you've got losses coming from years with a 21% corporate tax, which is what happened in the TCJA reduced our corporate tax from 35 to 21%. And the carryback is going to go back to 35% years. So people are happy about that, but they're going to think twice and maybe 3 times about applying losses against GILTI preferred income and also against income fully offset by the foreign tax credit. That's just a waste of those losses. So it's going to be company by company, and the modeling is going to be ferocious. The other last point I'll make about this is, to the extent the losses are attributable to payments, deductible payments to foreign related parties, they can actually throw people who are not under the base erosion anti-abuse tax into that tax. So some people will not take the loss carryback, even though it would benefit them tremendously, because they're deathly afraid of going into the B. So it's a real tricky set of decisions that people have to make. And it's going to be, it'll be company by company. And the other thing I would mention about this, I don't want to go on too long about it because it is complicated, but it's a weird provision because it applies to losses in 2018, 2019, and 2020. And the ostensible purpose was to put money in the hands of people. Well, as a result of the epidemic. Well, 2018 and 19 were not epidemic years, so it's going to apply sort of randomly in those years to people who happen to have losses. And 2020 isn't over, so who's going to get money on the basis of 2020 losses? For a calendar year taxpayer, we're not even halfway through the year, so we don't know what the loss is. So it's sort of a weird provision to me, but it is potentially a hugely expensive provision. The other thing the CARES Act did, I'll just mention this, and which intersects with the net operating loss rule, is that it relieved limitations on the interest deduction that the TCJA had put in. And that's also complicated in its own right. But the bottom line is that the limitation went from 30% of taxable income under the TCJA to 50%. And so the two interrelate, because if you claim 50%, say in 2020, which is when people would be expected to borrow money, that will increase your net operating loss and make your job of deciding what to do on the NOL provision even harder. So there you go. That's a complicated statute, and it passed on March 27. So, people are just beginning to see the implications of that.
Well, I guess if there's a silver lining, it looks like there's still going to be plenty of work for tax advisors coming out of that.
I would say, yeah, a lot of it's going to be modeling. I think the people who are going to get very, very fat on this are going to be the accounting firms. I mean, yeah. there's a lot of number crunching here.
Totally. Now, shifting the focus a bit, I know from our talks over the years, David, that you have doubts about how realistic large-scale multilateralism is in tax. And I have in mind now the OECD's 2 Pillars project, which was supposed to sort of be delivered to the world this year. with everything that's gone on, should we all be skeptics about this initiative?
Well, I don't advise anybody to be or not be a skeptic. I'm a skeptic. I was a skeptic a long time. I mean, it has nothing to do with the pandemic at all. I think trying to get 134 people together to agree on anything specific is kind of crazy. And you know, the idea of agreeing, the problem that we're facing there, I mean, there's a lot of problems here, but two of them are this. First of all, the idea of changing income tax principles that have been around for nearly a century to accommodate heaven only knows what strikes me as just a fool's game. I mean, I just don't see that happening. But even if there was agreement to do that, and there seems to be at some level agreement to do that, tax depends on rules, and rules need specificity, and that's where the problem is. One can agree forever, for example, that income should apply where value is created. That's not a big fight. Everybody agrees with that. But the problem is, where's value created? And in these cases, you're going to get, when you get from the very general, which is where they are now, down to a more specific discussion of what these rules actually mean, I will be astonished if they can achieve agreement. I just don't. I think they're chasing the wrong target. I don't think it should be changing income tax principles. And I think even if I agree that they should chase that target, I think the idea of reaching agreement on specificity is, I mean, I just think their reach exceeds their grasp, to quote a famous poet.
Yeah. Well, how about even if Pillar 2 doesn't get off the ground, do you think more countries might copy the US's guilty and beat rules? You mentioned those flat minimum tax rates there, and the concept of minimum taxation for offshore corporate income is having a bit of a moment right now.
Well, I think they might. I actually just had occasion to go through the Pillar 2, the OECD materials on Pillar 2. They're very complicated. And I don't quite understand what happens if most countries adopt them, but one or two countries said we're not doing that.
Who takes turns of taxing and
the big fight in the U.S., frankly, is going to be whether you blend all CFCs or whether you do it CFC by CFC. I mean, I think everybody's aware of that. That is a huge issue in terms of the U.S. multinational community. If you did this, if you applied guilty on a country-by-country basis, you would basically be ending deferral, and it would be really tough on companies. And they successfully warded that off in the United States. I can't imagine the United States going along with that on an international basis. And if they don't, I don't know what happens if you have a sort of divergent guilty regime in the United States and a sort of a country-by-country guilty regime abroad, with some countries not opting in. Again, getting agreement, the OECD has carefully avoided specificity. And the problem is, tax is a very specific discipline. You need specific rules, and I just don't see agreement forthcoming on any of that. But to answer your question specifically, I do think some countries will adopt something like guilty. Guilty is from a U.S. tax policy standpoint, guilty is a step in the direction of reform. It basically is a major step toward ending deferral, which of course U.S. international tax policy people have been talking about since 1962.
Yeah. And how about taxing the tech companies, the internet companies? Because the Pillars project started out all about the tech giants, and then the mantra was, no, don't ring-fence the digital economy. We've got to apply it to all consumer-facing businesses, multinationals. But now many consumer-facing businesses are going to be deep in losses for some years,
right,
while many of the tech companies are doing okay. So I wonder if digital services taxes, which countries have been imposing supposedly temporarily, are actually here to stay and are likely to proliferate and maybe harmonize.
Well, I think they're likely to here to stay. My own view is that the right approach for the OECD or for someone is to try to bring some degree of harmonization to either digital service taxes or alternatively, although I'm a little less sure here, gross withholding taxes. In other words, I think they ought to abandon the idea of some kind of net income tax approach. And from my way of thinking, the right approach to dealing with digital businesses is a VAT. I think that would make some sense. And I think the OECD, or again, someone could really be helpful in trying to bring a degree of harmony to that approach. I don't understand why the insistence on doing this through a net income tax, which strikes me, as I've said, as misguided. Yeah. But I do think that since the digital companies, first of all, let me tip of the hat to the digital companies, because this was a big digital project in its initially, and they basically sold everybody on the idea, oh no, we can't stop there, it's got to be everyone else. I mean, it still seems to me a project that countries are going to want to tax the digital companies, because they're doing, if anything, look at the very fact that we're on Zoom. I mean, they're doing fine, they're making money. So I would expect countries are not going to back down. And unless somebody comes along and tries to bring some kind of harmony to this process, we're going to have each country go in its own way. That's what I think is going to happen.
You mentioned a VAT. Do you think there's any prospects of the US introducing a consumption tax as one of the ways of trying to pay for these measures?
I would tend to doubt it. The problem with a VAT in the United States has always been threefold, really. The Democrats see it as regressive, and the Republicans see it as a money machine. And Larry Summers, who was the Secretary of the Treasury, once quipped that, you know, if the Republicans ever realized how regressive it was, and the Democrats ever realized what a money machine it was, you could get some harmony. But there's another problem in the United States, and I think it may be insurmountable, which is the states. Because the states see the indirect taxes as being in their purview, which has historically been true, and they think that if there were a federal VAT, they would be crowded out, which might well be true. And so that you'd get ferocious opposition. There already is ferocious opposition from the states, who have, on an issue like this, they would have a lot of power, a lot of clout. So I don't see it happening. On the other hand, I don't see any way that we're going to get in the United States through the income tax enough revenue to do what we want to do. I mean, it's just too politically charged. So on the one hand, we absolutely, in my opinion, we ought to have a VAT. On the other hand, it looks politically very, very difficult. Of course, everything is very difficult politically in the United States right now. So
sure. This is maybe more an economic question, but is there a lot of discussion in the US about how the Treasury is going to pay for the CARES Act and this relief? Is it really just more debt? And
well, I mean, I've been asking, you and I had a brief chat about that. I think what's going to happen is the Treasury is issuing a huge amount of securities, bonds. I'm assuming that they will pay off those bonds are going to bear interest at astonishingly low rates, because our interest rates are almost zero. They're very low. So, you know, all the people screaming about debt and you know, and comparing it with the past, I don't know. Of course, the interest rates could rise, but I don't see that happening anytime soon at all. And so the burden of carrying this debt is not so huge. When it comes to pay it off, I think they're going to have to just print the money to do it. I don't see any. I'm not an economist, but I don't see us raising taxes to do it. That's a non-starter, I think.
Well, we've seen that money printing, you know, has, despite all the economic orthodoxy, has not led to inflation in recent years. So
right.
That might be what's down the track, but it's all a bit unprecedented. Heading back to tax, I'd like to ask you about international tax disputes and whether you foresee more or fewer of these as countries close their borders and deal with the effects of this pandemic.
Well, I think there are factors pointing both toward more disputes and factors pointing to some extent toward fewer disputes. Let me take the latter part first. I think we're going to see a period of time, maybe quite an extensive period of time, in which international trade is going to be very much diminished. If there's less international trade, there's less occasion for disputes, and in that's going to temper a little bit the disputes that we might otherwise have seen. I have thought for some time that the BEPS project would lead to more disputes, because my view of BEPS, I think BEPS, by the way, was a phenomenal achievement by the OECD. I mean, I was astonished to see it. I thought it was just an amazing thing. But my view of what BEPS accomplished is a little different from what the OECD thinks it accomplished. I think what BEPS did was raise the visibility of international taxation among the general public. And for a while there, international tax issues were finding their way into the front pages of mainstream newspapers. And maybe they still are. And so I think that the awareness of international tax and cross-border commerce, et cetera, that's a big deal. And that I've thought what will happen is a lot of countries will wake up and say, geez, we have a case to be made here. So I would have thought, but for the epidemic, that we were headed into a world largely attributable to BEPS, where there were going to be more disputes, more. The tempering factor is if trade falls off so much that prevents that from happening to some extent.
So related to the disputes is treaty arbitration, with which you've had some experience. What are your thoughts on that and its relevance at this point in time?
Well, I think the treaties are the only game in town to resolve disputes. I mean, I don't know what else we're going to do except you rely on the treaties. And I think you do need mandatory arbitration. I mean, the U.S. experience with mandatory arbitration is almost uniformly positive. We've had mandatory arbitration in place with 4 countries since 2004 or 5, about 15 years now. And we've only had 1 country with which we've actually had to go to arbitration. Let me say, first of all, that the purpose of a mandatory arbitration rule in a treaty is that there never be an arbitration. That's what you're aiming for. What you want to do is you want to have the competent authorities get serious and resolve the case. And I think, in my experience, personal experience, this was with Belgium. I had a case that was pending for 7 or 8 years. As soon as Belgium signed up to mandatory arbitration, we got to the table and resolved it in a matter of months. I mean, that's what you want. You want pressure on the process. Now, our experience with actual arbitrations is limited, as far as I know, to Canada. And that's because the CRA is a little slow to pick up on the new world. And they're a pretty aggressive tax agency. I think it's changed a lot, but there have been a number of actual arbitrations. I had one which was settled literally after the arbitrators had been appointed, so really right on the threshold of going to the arbitration. But there have been a number of them. How many, at least in the United States, is a very closely guarded secret. I mean, you'd be better able to get the nuclear codes than to find out how many arbitrations there have been with Canada. I have heard, you can get probably more information on the streets of Ottawa or Toronto than you can in the US, but I have heard anywhere from 3 to 8 arbitrations, all won by the United States. My sense is that the truth lies somewhere in between, I would guess 5 or 6. I have no inside knowledge on that at all. I've talked to people who swear they have inside knowledge, but they say different things. So I would guess we're in the 5 to 6. And there's an interesting dynamic in the US that has developed, which I think is kind of humorous, proving once again that the only law that never gets repealed is the law of unintended consequences, which is that the IRS is now very reluctant to take cases to arbitration with Canada. Now, why? Because they won all of the arbitrations that there have been, and no IRS employee wants to be the first person to put a case in arbitration that the US loses. So, I mean,
Yeah.
it's palpable. It's very strange. But I'm a big fan of it. We had a lot of internal dispute in the United States in the early 2000s about whether arbitration made sense. There was talk that it would be conflicts of interest, that it would take a long time, it would be expensive, all sorts of things. None of that happened. None of it. I know quite well one arbitration that I was not involved in because I know one of the arbitrators quite well, and it's all done by telephone. With Canada and I think probably now with other countries, we did an astonishingly intelligent thing, which is to get together and agree with them on all the procedural obstacles that could stop an arbitration before there was an actual case. So how many pages would the briefs be? What would be the time for submitting? How would this be done? Who would be chosen? All of this stuff is laid out in great detail. And then we have baseball arbitration, which is, to my way of thinking, the way to go. Because baseball arbitration, as you know, the arbitrator's powers, the panel's power is very restricted. They get to choose between one country's position and the other country's position. And they can't compromise. They can't make up their own answer. They don't write opinions. The result is a number. And then they go away. They fade into the distance. And countries come forward and say, oh my, this interferes with our sovereignty. But I think that objection is either in bad faith or is just nuts. I mean, the interference with sovereignty is entering into the treaty in the first place. What's the point of entering into a treaty and then taking steps so that it doesn't function appropriately? I just don't get that. But that's a pretty widespread view. So I'm a big fan of mandatory arbitration. I think the world is coming around to see that it's got to be done. I had occasion recently to tell a major country that is very vocal in this area and that is very, I won't identify, but very interested in attracting investment to its borders, and they've announced all sorts of tax incentives and tax holidays, and they don't want to hear it. But I told them, if you really wanted to attract investments, what you ought to do is say you'll agree to mandatory arbitration. Then people would feel a lot more secure investing in your country. They don't listen, of course. But I'm a big fan of mandatory. I've seen it work. I saw all the objections. In our case, none of them have panned out. And now we just adopted 4 protocols, and I think 3 of them have mandatory arbitration. So I haven't carefully looked at that, but our number of treaties with mandatory arbitration has grown from 4 to 7. And I think countries have expressed their willingness to go forward with that. I think that would be a great thing to do. And I think that, I don't know whether the OECD could put more pressure on it. They tried in BEPS without a great deal of success, but I'm a big fan of it. And I think that we need it because we need a dispute resolution mechanism.
Yeah, Australia is including it in many of our treaties now. I wanted to ask about the type of arbitration, because some people like Philip Baker advocate against the baseball model and say there should be reasoned opinions because this would develop the international tax law and stop us reinventing the wheel each time and give us some more guidance. What are your thoughts about that? I
think it's 100% wrong. It's just completely wrong. The idea here is, look, the mutual agreement procedure is a dispute resolution mechanism. It's in all treaties. All treaties have it. The OECD has it. The UN has it. Everybody's got it. So the question is, how are you going to make that work? We're not trying to create a body of jurisprudence. That would take time, and it would give power to the arbitrator. All the objections to arbitration come out in spades when you talk about writing opinions and giving power to have precedent. And also it's just going to bring out the worst in the whole world of potential arbitrators. It's going to create mini judges. I don't like it one little bit, and I've had big arguments with Philip about that. I think I did in London at a session in London. I don't understand that position at all. I want a practical solution here. We got international tax disputes, and we got a lot of them. You know, I mean, there are countries, I will say India, when last I looked, it has been a while, had over 60,000 pending tax disputes. And we got to get rid of these things. I mean, if we want to promote cross-border commerce, I can't think of anything that would give a greater shot in the arm than that. And frankly, I will say one other thing about this, because you're pressing a number of buttons that I've talked about. The organization that really could play a role here, a big role here, is the United Nations. Because the developing world is semi-suspicious, maybe even outright suspicious in regard to the OECD. But I think in the UN, where they've got a vote, the UN could play a role by vetting arbitrators, maintaining a list of people who they would certify to the developing world. I think that would go a long way, could go a long way, to relieving the anxiety of developing countries about, for example, entering into an arbitration with the US. I mean, if you had the UN say, look, here's this guy from, I don't know, from Norway, and we certify him as an objective arbitrator, maybe that would help. Maybe that would help.
Now, David, we have a provocative question come in through the Q&A.
Okay.
And it is asking why the US is so happy with binding arbitration when it doesn't support most other binding international institutions like the WTO and ICJ.
Well, well, first of all, one thing you have to be careful about when you talk about the U.S. is, and this is a mistake that lots of people make, is the U.S. speaks with many voices. Yeah. I would certainly not, I don't know too much about what the U.S. has said about the ICJ, but I will say that the idea that the U.S. doesn't support the WTO, I mean, if you're referring to the Trump administration, we'll go off into a sort of a political discussion. Yes, this administration has not been good on anything internationally, as far as I can tell. But I would think hard before concluding that the U.S. doesn't support international institutions. We actually have done a lot with respect to the OECD, although we're not in the MLI and we won't be. But I mean, a lot of that is our own very messy, very terrible political internal politics. I limit myself, at least for purposes of this session, to tax. And in tax, we did go into mutual mandatory arbitration. It has worked for us. And remember, the point is not to do the arbitrations. The point is to put pressure on the process that has been around and that has existed for decades, which is the competent authorities get together and compromise, and we get a solution and we move on.
Yeah. Can I ask David about a more specific topic of interest deductibility?
Yes.
Because you mentioned what we're all observing, that companies are going to need to borrow, and there's a lot of debt descending on the economy at the moment. Interest rates are fairly low right now, but there will be a large volume of debt and interest. And I wonder if you think, and you mentioned the impact of that on the US earnings stripping rule for interest deductions.
Right.
Do you think we're going to see some changes to countries' thin capitalization, earnings stripping rules to accommodate the greater indebtedness in the economy?
Well, I mean, that's what we did in the CARES Act, but we did it on a temporary basis. We didn't change that rule permanently. There is a bit of a concern among observers of the tax system that under the cover of addressing the pandemic, voices in Congress will put through rules on a, quote, temporary basis that won't turn out to be so temporary. Mm. The Tax Cuts and Jobs Act looms over almost everything going on in international taxation in the United States. It is just infinitely complicated. It was before the CARES Act. And by the way, we're likely to have another statute which may have tax in it. Don't know what it might be. There are voices out there arguing that the base erosion anti-abuse tax should be relieved. The rate should go from 10% to 5%, or various accommodations. I don't know. I doubt that will go through, but you know, in the current circumstances, taxation is not the lead horse in the discussions. So we, as tax people, we see these statutes. I mean, the CARES Act came out March 27. I'm not even sure. I don't know how long it was before it was proposed. From proposal to enactment was one of the shortest times in history. And who knew what was going to be in there, and how many tax people really had a say in that? So I think that temporary accommodation for borrowings in 2020. Yeah, I can see people might want to do that. But the Tax Cuts and Jobs Act, one of the things it did to raise revenue to offset the substantial money that it gave away, because it gave, remember, we reduced our corporate tax from 35% to 21%. So we had to do something to raise revenue. One of the big things it did was to reduce the earnings stripping limit from 50% to 30%. And you may know that before the TCJA, the earnings stripping rule was a farce. I mean, it was very, very complicated, and it didn't do a whole lot of anything. And it only applied to payments to related persons who were not subject to taxation. Now, in the TCJA, they went from 50% to 30%. But they also had it apply to all interest, everybody, including interest paid to unrelated persons. Yeah. I mean, you can borrow from a money center bank, and you'd still have that same limit. What the CARES Act did was raise the TCJA approach from 30 to 50%, but it did not restore all the nonsense that was in the former earnings stripping rules. So maybe there's hope that this will only be temporary, or at least won't completely undo the TCJA rule, which I thought was I don't like statutory provisions that hold false promise of doing things, and that was certainly one of them.
Now, I've just got really one more question. So if those in the audience want to suggest any more questions through the Q&A, we've got about 5 or 10 minutes left. David and I plan to talk for about 45 minutes. So we do welcome any questions through that Q&A button on your screen. And my question, David, is about tax havens, who have been a target for many years now, and many of the attractions of tax havens have waned in recent years, with countries passing all sorts of legislation to prevent both sort of individuals and families putting passive income in havens, but also active businesses using tax havens strategically. Do you think, with the pandemic or pandemic aside, what do you think the future is for tax haven companies and offering that as a competitive advantage?
Oh, I think those days are gone. I think, from what I hear, I mean, I see a little slice of the world, but I hear a lot about people restructuring to avoid havens, to avoid low tax countries generally. I think the European Union has been moving strongly in that direction. We haven't mentioned that in this conversation. They've been moving strongly in that direction. I mean, the GILTI rules make it, the GILTI really is pretty extensive. It applies to everything that's not a few very limited categories of income. Now, there is a big fight in the United States. Fight is the wrong word, because the Treasury is about to raise the white flag, but they're gonna have a high tax exception to tested income, which is going to be a fairly big deal for U.S. companies. The interstices of these international provisions that they did in 2017 are really, really tricky. And the interrelationship among these provisions and between them and the pre-existing rules, because the TCJA did not create a new regime. What it did was it layered a new regime on top of the old regime. And there were a lot of assumptions made about how the old regime operated. So we keep on seeing very odd effects. And I've been writing about that pretty consistently. I've got a whole bunch of things in the works right now. The other thing to mention about that may be interested to this audience is that Congress in 2017 said almost nothing about treaties. Oh, and I say almost nothing. There was a very indirect, oblique reference in the interest deduction rule to treaties, but that's the only thing in the entire statute. So we have a lot of very interesting legal questions coming out in the United States about the relationship between that statute and the U.S. treaty network. For example, we completely abolished our deemed paid foreign tax credit, except for GILTI and Subpart F, and yet all our treaties require us to give a deemed paid foreign tax credit. So what happens there? And there's a lot. I'm doing a lot of writing on that. And I think a lot of other people are thinking about that. That's a big issue going forward.
It is. Look, and that picks up something else I wanted to ask. We've got some great questions coming through from the audience, and one of them is about bilateral treaties. And you and I have talked about this, and with the sort of focus inwards and more protectionism and more less multilateralism, particularly from this pandemic, do you think bilateral tax relations and bilateral treaties and most favoured nation relationships are going to become more important than ever, and that the focus of international tax will really be at the bilateral or the small group of countries level?
Well, I do think, first of all, I do think that the treaties are out there. They exist. In the United States, they're the supreme law of the land. We have a treaty network of somewhere mid-60s, 64, 65 treaties. Those treaties are going to be very, very important. So bilateralism, to the extent that the trade picks up, which I think it will do eventually, although slowly, the treaties are, as I said, the only game in town. So I do think that the treaty relationships are going to be extremely important. It's going to take a while. I mean, it's obviously going to take some time. But I'm a big believer in the treaties because I think that by providing the means of resolving disputes, that's the most important thing treaties do.
Yeah. Now we have a question on arbitration, and it's the question about what role does the taxpayer have in an international arbitration? Are they shut out on the basis that the parties to the arbitration are the two competent authorities, or can they influence the outcome in some way, even if they don't have a seat at the table?
I think the answer to that question depends crucially on understanding what arbitration in the MAP does. And that in turn depends on what the MAP is. Yeah. The mutual agreement procedure is a procedure in which the taxpayer does not participate. The two countries get together and they discuss. Now, in the United States, this is not true in every country. We have a pretty transparent competent authority. So if I want to go in, as I'm doing right now in a couple of cases, and talk to the competent authority about a case and where I think the U.S. should be and what they might do, that's pretty easy. I pick up the phone. It used to be I could walk over. It's a couple blocks away and talk about it. And so the taxpayer's involvement in the resolution in the MAP is indirect, but at least in the U.S., it's not absent. Yeah. Mandatory arbitration doesn't change that. Mandatory arbitration is simply a tool for getting the competent authorities to take the whole thing seriously and get to a result. So no, the taxpayer is not in there. I know some people envision the taxpayer there with a long cloak and a wig and arguing one thing. This is not a commercial arbitration. Yeah. By the way, I think commercial arbitrations as a way of resolving tax issues are nuts. That's another thing I have a real strong view on. But mandatory arbitration is simply a means of making the MAP work, and the MAP itself, the actual discussion is government to government. It always has been. That's the way it was envisioned.
What is your view on using investment treaties and the like to resolve tax disputes?
Well, I was a witness in two of the biggies, and I was horrified. I mean, it's a lawyer's dream. They gave each side, the lawyers had 28 hours to argue. I said, you got to be kidding. In the Supreme Court of the United States, the most important cases, each side, it's at most an hour, maybe an hour and a half, 28 hours. 2 weeks I was in The Hague while this went on. This was unbelievable. Do you know what lawyers find to talk about when they have 28 hours to argue? Yeah. They talk about everything and repeatedly. It was the most incredible waste of time and money I've ever seen. Plus, it's exacerbated by the fact that as far as I could see, this was a tax dispute. No one in that room, with the possible exception of me and the associate who accompanied me, knew anything about the issue at all. They talked about it as though we were talking about natural law. I think that is the strangest thing for a country to do, to put a tax issue, a tax dispute, into a bilateral investment treaty. Much better to try to figure out a way to get it into competent authority. Yeah. That's my perspective.
This is sort of the $1 million question, David, but do you have a view on what sort of tax reforms would encourage productivity in our crippled economies?
Oh, wow. I am supposed to be working on incentives and development of a major South American country and their tax system. The answer is I'm open on that. I'm skeptical about I think a lot of the claims made by economists for effects of the tax system on this, that, and the other thing tend to be, in my view, overblown. They tend, the assumption seems to be generally that if a particular provision points in a certain direction, it will get you in that direction. And I don't think that's necessarily true. In fact, I don't think it's true at all. So, I mean, for example, we lowered our corporate tax rate. The Tax Cuts and Jobs Act is great, even before the epidemic. We lower our corporate tax rate, and everybody's going to come back to the United States. Well, no, they didn't come back to the United States. Why? Because their markets are abroad, and so I'm very skeptical about using tax for incentives or disincentives. The tax system, I know you've heard this, ought to be used to raise revenue for the government. That's what it's there for. And all this mucking around with, behavioral influences or disencouragements, I just think it's not right. It's not operating the way that people claim for it.
Yeah. Do you think, these are all great questions from our audience, so thank you. We'll just have a couple more of them before we wrap. We have a question about BEPS was looking to take the world down a path of greater harmonization in international tax and having our domestic tax systems be more and more intermeshed and interrelated. Do you think now with the revenue pressures on countries and the difficulty of conducting diplomacy at the moment, we're going to stay on our parallel tracks or move towards more polarization in our tax rules? Or do you think
I never thought BEPS was going to have that. I never thought BEPS would have that result. I mean, as I told you, what I thought BEPS was, the achievement of BEPS was not promoting harmony. The achievement of BEPS was in raising the visibility of international taxation. We live in a world of nation states, and all of this idea that there's harmonization. Yeah, you can get harmony if you discuss tax issues at the highest general level. Income should be where value is created. I love that because that's a great example. Nobody's going to dispute that.
Yeah.
But when you start putting bells and whistles on it and converting it into a rule, and you need rules for taxation. You can't do it on the basis of any kind of general concepts. When you start talking about specifics, countries are going to go their own ways, and that's to be expected. Yeah.
Now, you mentioned that the TCJA was intended to encourage US multinationals to bring their earnings back, bring their operations back, bring their factories back, but it didn't quite happen to that extent. What's been your observation of the results of the beat and the guilty in these initiatives?
Well, I think it's early to really know. I mean, I certainly haven't seen the gross statistics, but one of my close friends, an economist, did a study of the securities filings by major multinationals, and he found only a very limited number of US multinationals that had repatriated intangible property, and most of them were sort of one-off reasons. I mean, there was no general repatriation back to the United States. First of all, guilty, although it is a minimum tax, is taxes at a lower rate than foreign-derived intangible income. So assuming you're dealing with bringing your intangibles back and exporting, you're going to pay more tax. So on a pure tax basis, if you assume that's what motivates people, you leave your intangibles abroad. So I don't think much is going to happen. On the beat is such a crazy tax, and it applies in such a weird way, and it's also subject to, I think, fierce objections on the ground that it violates treaties in several respects. I don't think we're anywhere near knowing what that's going to do.
Okay. All right, I've got two more questions. Thanks, David, and for taking most of these without any notice. What was the question? Let's see, our Q&As. Yes. What do you think about the idea that's slated every now and again of replacing the corporate income tax with some kind of a cash flow tax? a destination.
Well, we talked about that. We talked about a cash flow tax, and the problems, there are a lot of problems with it, I think. Some would say that in effect, what they did in the TCJA derives from that idea. I don't see it myself. The cash, I wrote a lot about that. I didn't think it was a great idea. It was going to affect a lot of people, and it was beaten back by the companies. I don't think that's got much of a future in the United States, at least. Yeah. I mean, I think the VAT has more of a future than that, frankly.
So lastly, David, this pandemic is a big crisis we're going through right now, and it may end up being the biggest crisis in the lives of those of us living now. And it is very hard to predict the future, but I wonder if you can speak generally about what you think the role will be for taxes and for tax advisors and for international tax coordination, even in the midst of a very changing world.
Well, let's put it this way, Chloe. I'm operating on the assumption that you know, I'll have a job to do for as long as I want. I think, you know, taxation is here to stay, and this will eventually pass, and the world will eventually get back, slowly, I think, but it will eventually get back to more cross-border commerce. It is a globalized world. We can't put that back in the bottle. That's gone. So I think international cooperation, international taxation is, in a way, it's going to be bigger than ever, because already before the epidemic, we were moving in the direction that everything was international. I mean, from being a sort of a subset of the general tax world, international sort of swallowed most of it. And I think we're going to proceed in that direction. But this is definitely a big hiccup in that move. It
is. But it does seem to me that the technology that we have has ironically brought us closer together in this pandemic. You know, we probably wouldn't have organized a IFA event with David Rosenbloom if you weren't in the country in the previous world. And now it occurs to us, well, we'll actually, we can do this.
So, and I do it, I do it every day, pretty much. I mean, it's becoming the thing. I may not go back to flying around. The airlines ought to worry about this.
Yeah, well, that's right. I mean, for some things, nothing is quite the same as face-to-face, but this sort of thing gives me optimism that the shutters aren't all coming down, and that the international cooperation cat is out of the bag.
No, and you know, there's still a lot of activity from my academic perspective. The students are still coming to the International Tax Program at NYU. We have a healthy class that's enrolled. I don't know how we're going to teach them. We probably will teach it all remotely. But we finished this year at the International Tax Program through remote teaching, and it went pretty well. I mean, I'm not sure. The full experience requires, I think, presence in New York, but it was better than I expected it to be.
Yeah. Well, that's terrific, David. And I want to thank you so much for your time today. I think we're going to go back to Paul in a moment to close the session, and we'll just have to have a virtual round of applause. But thanks also to the large audience we've had, and thanks for your participation, everyone.
Happy to do it. Good to see you, Chloe.
Cheers.
And thank you very much, Chloe, and David and Chloe. That was a marvellous session, deep and useful, mucking around, as you put it, in a slightly different context. But thank you. We thank you so much for sharing your time, knowledge, insights. Whatever normal will end up being, we now have more in our knowledge kit bag to deal with challenges and questions ahead. Ordinarily, David, we would give you a modest token of our appreciation, like a bottle of Australian wine. On this occasion, we hope you'll accept a credit note to be redeemed on your next trip down under.
I'll accept that. That's great.
Thank you, David.
Well, thank you for the opportunity. It was a lot of fun.
Thank you. Just for our members and those on the session, we have in the pipeline further IFA webinars and events, which we will promote in due course. Specifically for members, just a note that you'll receive an email soon advising of our AGM to be held on 15 June. So keep an eye out for that, please. Thank you all very much, those who have attended this IFA webinar. Stay well, stay healthy, and we hope to see you all soon. Thank you very much.
Thank you.